Hello, you're listening to The Supreme Court by Brighton Ashford, hosted by Brent Ristow.
Hello and welcome. In this episode, we will look at United States Supreme Court case number 23719. That is Donald J. Trump v. Norma Anderson et al. Certiorari was granted. That means the court agreed to hear the appeal on December 19th, 2023. And the question presented to the court, the issue they have been asked to resolve is, did the Colorado Supreme Court did they make an error in ordering President Trump excluded from the 2024 presidential primary ballot? So that is the question presented. That's obviously a very broad question. Now, this case comes to the United States Supreme Court from the state of Colorado and a state district court. More specifically, the case Anderson et al. V. Griswold and Trump, that is Colorado District Court, City and County of Denver, State of Colorado, case number 2023 CV 32577. Now, in this episode, we will discuss the parties to the litigation, brief look at jurisdiction and procedure, and kind of the path the case has taken to get to the Supreme Court. And we'll just have a broad discussion and analysis. We'll look at the judgments of the district court and the Supreme Court, including some of the dissents. And then at the end, we'll make a prediction of what we can expect moving forward in the litigation and what we anticipate the Supreme Court will do next. Looking at the parties to the litigation, starting with the defendants and Donald J. Trump Jr. He's the former president of the United States. He is obviously the purpose of the litigation is he is a candidate for president in 2024. If you would like to know more about Donald Trump's views on things, I encourage you to go to X, Elon, or Truth Social, where you can get that information directly from the source. Again, this case arises out of Anderson et al. V. Griswold and Trump. Who is Griswold? Griswold is Jenna Griswold, the 39-year-old Colorado Secretary of State. In Colorado, the Secretary of State is an elected official. On January 4th, 2024, in the Washington Times, in an article by Mallory Wilson, Ms. Griswold is quoted as having said, Donald Trump is trying to argue he did not incite an insurrection, while two Colorado courts at this point have determined that he did. And then Trump goes on to argue that even if he did incite an insurrection, well, the Constitution doesn't apply to him. I don't think that's right. In a January 2nd, 2024 article in The Hill by Sarah Fortinsky, when asked to blame who is to blame for perceived political violence, Ms. Griswold is quoted as saying, I would say Donald Trump and Republicans in Congress and high-ranking Republicans across the nation who have not stood up to condemn the rhetoric of violence. In a earlier 20th December 2023 article in the Huffington Post by Jennifer Bendery, Ms. Griswold is quoted as saying, I've been concerned about violence and threats of violence since Donald Trump incited the insurrection. I've received hundreds, if not thousands, of threats at this point. Now, turning to the petitioner in the case, again, this case arises out of Anderson et al. V. Griswold and Trump, looking at Norma Anderson, the named petitioner. Consider her representative of the petitioners. The other petitioners will have different personal details, of course. Looking at Norma Anderson. Norma Anderson served in the Colorado legislature from 1987 to 2006 as a Republican. She resigned for family reasons. While in the state legislature, she sponsored important state legislation, which created the Colorado Department of Transportation, and she helped create a 20-year transportation plan. She also authored the School Finance Act of 1994, which provides more equal funding to each school district. In a February 25th, 2021 article in the Denver Post by Doug Friedenash, Ms. Anderson is described as having left the Republican Party and become an unaffiliated voter in Colorado. And that will be important for our discussion of standing below. Also, in the February 25th, 2021 article in the Denver Post by Doug Friedenash, Ms. Anderson is quoted as saying, "It doesn't matter if someone is a conservative or not. What matters is whether you like and support Donald Trump. Republicans have lost their way with Trump. This is not the Republican Party anymore." She goes on to say, "The Republicans nominated an oversexed playboy who has spent his entire career lying to people." It's worth noting that in that article by Doug Friedenash, the author describes Miss Anderson, and he describes her from his personal experience working opposite her in the state legislature, meaning Doug Friedenash, the author, used to be a Democrat. Describes Anderson as a conservative's conservative. Anderson was always fair, transparent, and collaborative. Turning to jurisdiction, does the court have jurisdiction? You remember from Civil Procedures podcast or podcast sections you may have listened to. For the court to have jurisdiction, you need personal jurisdiction and subject matter jurisdiction. You need to have standing. And standing, if you recall, is some injury. That defendant caused that injury, and the court has redressable, and that injury is redressable, or the relief sought by the court can redress that harm. In essence, in this case, petitioners are claiming that they would be harmed should Trump be allowed on the ballot. The Secretary of State and Trump being on the ballot themselves would cause that injury, and the court can redress that by preventing Trump access to the ballot. In a December 22nd, 2023 article in Business Insider India by Lloyd Lee, Donald Sherman, the Executive Vice President of Citizens for Responsibility and Ethics in Washington, or CREW, which is a watchdog group that helped file the Colorado State Court lawsuit. Mr. Donald Sherman is quoted as having said, Colorado law requires that in order for a voter to challenge the placement of the candidate in the Republican presidential primary, that they be Republicans or unaffiliated voters. So in order to have standing, they had to be Republicans. Again, that's not entirely true. They can be unaffiliated. As I stated earlier, Ms. Anderson was described as being unaffiliated. Looking at Colorado Statute 1-4-1203, it reads as follows: at the presidential primary election, an elector that is affiliated with a political party may vote only for a candidate of that political party. Goes on to read, an unaffiliated eligible elector, that's somebody allowed to vote, may vote in a political party's presidential primary election without affiliating with that party. That is going to be important for discussion later. What it's saying is that you can't be a Democrat and vote in the Republican presidential primary. Now, interestingly, as I mentioned earlier, Ms. Anderson was described by Mr. Friedenash as being unaffiliated. She left the Republican Party. In the judgment of the district court, state district court entered in this case, and the findings of fact, Ms. Anderson is described as affiliated Republican, and those descriptions will become important for a brief discussion later. Also in jurisdiction, again, you need personal jurisdiction and subject matter jurisdiction. There's no indication that any of the parties have contested personal jurisdiction. Looking at subject matter jurisdiction, to be in state court, you have to have state court grounds. And the state court grounds in this action are numerous electoral state statutes. The state statute of particular interest here is State Statute 1-4-1204. Names on ballots is the title of the statute, and reads in pertinent part, in a challenge to the listing of any candidate on the presidential primary election ballot must be made in writing, must provide notice of an alleged impropriety, and that language is important, that gives rise to the complaint. Goes on to read, the district court shall hear the challenge and assess the validity of all alleged improprieties. And then the party filing the challenge has the burden to sustain the challenge by, and this is important, a preponderance of the evidence. If we recall from our conversations of burdens of proof in the other podcasts, preponderance of the evidence is the civil burden of proof. You go to civil court, that is the civil burden of proof. You go to criminal court, that burden of proof is clear and convincing or beyond a reasonable doubt. One example from popular culture that you could use would be O.J. Simpson. Sorry, O.J. But if you recall, O.J. Simpson was acquitted of murder in a criminal context where the burden of proof was clear and convincing. So he got off on that one. But then was sued by the families in civil court where the burden of proof is preponderance of the evidence and was found to have caused their deaths. So think of that in that context. And just in the context of this case specifically, and this will tie into our analysis and discussion below, I would consider that insurrection is certainly a criminal charge and therefore may be in conflict with the preponderance standard in the statute. Turning to look at the case itself and the relief sought, the petition filed by Ms. Anderson et al. Reads as follows. Despite the Secretary's power and duty to exclude constitutionally ineligible candidates from the presidential primary ballot, the Secretary has not committed to excluding Trump from the presidential primary ballot based on his disqualification under Section 3. Based on historical practice, the Secretary will not independently investigate Trump's constitutional eligibility under Section 3 and exclude him from the ballot on that basis, absent a judicial order to that effect. Count 2 reads, declaratory relief that Trump is disqualified from office and that the Secretary may not take any action to allow Trump access to the 2024 Republican presidential primary ballot. What the petitioners are asking for is they're asking for the court to declare, the specific relief sought is the court to declare that Trump is disqualified under Section 3 of the 14th Amendment to the Constitution of the United States and is therefore constitutionally ineligible to appear on any Colorado ballot as a candidate for federal or state office. For the court to declare that any action by the Secretary allowing Trump to access the 2024 Republican presidential primary election ballot or any future primary or general election ballot in Colorado will be improper, and asking the court to enjoin the Secretary, to stop the Secretary from taking any action that would allow Trump to access the 2024 Republican presidential primary election ballot or any future primary or general election ballot in Colorado. That's how it reads. They're looking to keep Trump off the ballot and stop the Secretary of State from putting him on there. So what happens to the case? Norma Anderson et al. Petitioners file their petition to keep Trump off the ballot in Colorado State District Court. Very shortly thereafter, I believe it may even be the next day, Trump filed a motion to remove the action to federal district court. Once in federal district court, Norma Anderson et al. Filed a petition to remand the case back to state court. The federal district court found that they did not have any Article 3 standing. And if you remember from our podcasts, Article 1 applies to Congress. This is going to be important later. Article 2 applies to the president, and Article 3 applies to judiciary. So the judiciary had no standing to hear the case, is what they're saying. And their grounds for saying that is that Griswold, the Secretary of State, was never served. Now, Trump apologized for this because he thought Griswold was a nominal party. And what a nominal party is they're not a real party in the controversy. They don't really have any valid interest in the case. Trump's position was that Griswold was named as a defendant as required only under state statute, that she wasn't a real party in the controversy. I did call the Secretary of State's office, Colorado Secretary of State's office, looking for comment and what the Secretary thought was the central issue in the case. I left a voicemail with Public Information Officer Jack Todd, but have not heard back. What the federal district court found was that Griswold, the Secretary of State, is not a nominal party. She's a real party in the controversy because, quoting the federal district court, Secretary Griswold is a person who will actually make the decision to allow or disallow Trump's name on the ballot. They go on to say that because Secretary Griswold accepted service before Mr. Trump removed the case, and Griswold did not join in or consent to removal, that's important, consent to removal, the court finds that removal was defective, end quote. And if you remember from the podcasts on civil procedure, removal is the right of the defendant only. So if you're in state court and somebody wants to remove it to federal court, only the defendant can do that, but all of the defendants will have to do that. Now, just a further note, in response to the petition to remand filed by Anderson et al., Griswold, the Secretary of State and co-defendant here with Trump, filed a statement saying that she supports the remand back to state court. So the federal court grants the petition to remand. The case returns to the state district court. The district court then goes on to analyze whether Trump engaged in an insurrection and concludes that yes, by clear and convincing evidence, that Donald Trump, by his words, speeches, and inaction, engaged in an insurrection. Next, the district court analyzes a state's authority to regulate a presidential election, and the district court concludes that yes, states have the authority to regulate presidential elections. Now, the district court says that the Secretary of State cannot keep a president off of the ballot on their own unless there's objectively knowable facts. We'll talk about that in a minute in express conditions. However, the district court says the election code incorporates a 14th Amendment, and that incorporation gives the district court, the authority to regulate presidential elections because, remember, Colorado Statute 1-4-1204 says, quote, the district court shall hear the challenge. Now, the district court then analyzes whether Section 3 of the 14th Amendment, the insurrection section, applies to the president, and in this case, ex-President Trump. The district court concludes that no, Section 3 of the 14th Amendment, the insurrection section, does not apply to the president because the president is not an officer, as that term is understood under the 14th Amendment, and the court goes through a very nice analysis comparing other clauses of the Constitution for context usage of the term officer. So both parties appeal the judgment of the district court, asking the state Supreme Court to intervene in the appeal. And the state Supreme Court agrees to hear the case. In regards to the issue of whether Trump engaged in an insurrection, again, the district court said yes by clear and convincing evidence. The state Supreme Court says also yes. They agree with the district court that Trump engaged in an insurrection, but they also conclude that Trump acted with the specific intent to do so. You should listen to our criminal procedures and criminal law section podcasts for some clarification on the difference between general intent and specific intent crimes. Moving on to whether the state has the authority to regulate a presidential election. The state Supreme Court states that no party in this case has challenged the Secretary's authority to require a presidential primary candidate to confirm on the required statement of intent form that he or she meets the Article 2, again, Article 2, requirements of age, residency, and citizenship, and to further attest that he or she meets all qualifications for the office prescribed by law. Moreover, several courts have expressly upheld states' ability to exclude constitutionally ineligible candidates from their prescribed ballots. And they cite two cases, which we'll discuss here in a moment at arriving at that conclusion. The state Supreme Court then goes on to analyze whether Section 3 of the 14th Amendment, the insurrection section, applies to the president. And if you remember, the district court said that the election code incorporated the 14th Amendment, and that gave the district court the authority. The Supreme Court makes a brief historical note, and I'll say that this section in the judgment is incredibly brief for comparison to the importance of the topic. But the court makes a brief note about historically electors, those eligible to vote in an election, would vote for a slate of electors. That was an historical practice. However, the Supreme Court notes that that practice has changed based on state statutes that pledge electors to voted for political parties. And based on that historical shift, the Supreme Court concludes that the president is a proxy for the pledged electors. And therefore, the state Supreme Court concludes that Section 3 of the 14th Amendment, the insurrection section, applies to the presidency and therefore applies to Trump. Now let's look at the court briefly. The district court judge in this case was Sarah Wallace. She was appointed by Democratic Governor Jared Polis and assumed office on the 10th of January 2023, a mere 9 months before judging this case. Now looking at the Colorado Supreme Court, the judgment in this case was a slim 4-3 majority. Now, the Colorado Supreme Court is comprised of all Democrat appointees. The justices were all appointed by a Democrat governor. Now, the governor appoints justices to the Colorado Supreme Court after being forwarded nominees from the Colorado Judicial Nominating Commission. And that commission includes one citizen from each district in the state. And those citizens cannot be attorneys. However, there is, to my understanding, one attorney also on the commission. Now, those commission members are appointed by the governor. So although there are layers there, it all comes back to government appointees. Going to the Colorado Supreme Court still, one thing that I found interesting in looking at the determination and who the justices are, the 4-3 majority, the four, went to Harvard, Yale, Penn, and Virginia law schools. I would hazard to guess that those East Coast law schools might be perceived in some circles as being more liberally biased law schools. However, all of the dissents, and this was what was really fascinating, is that all of the dissents in this case came from justices that had attended the University of Denver Strum College of Law. In his dissent, Chief Justice Boatwright says that, in my view, the claim at issue in this case exceeds the scope of Statute 1-4-1204. The voters, the electors' action to disqualify former President Donald J. Trump under Section 3 of the 14th Amendment presents uniquely complex questions that exceed the adjudicative competence of the statute's expedited procedure. It goes on to say that dismissal is particularly appropriate here because the electors brought their challenge without a determination from a proceeding, e.g., a prosecution for an insurrection-related offense, with more rigorous procedures to ensure adequate due process. Justice Samore, in a very lengthy dissent, says that, in my view, what transpired in this litigation fell woefully short of what due process demands. Because I perceive the majority's ruling that Section 3 is self-executing to be the most concerning misstep in today's lengthy opinion, I focus on that aspect of the legal analysis. She went on for a very lengthy legal analysis. Justice Birkenkotter says in his dissent, quote, in my view, the majority construes the court's authority too broadly. And later, when discussing the language of Statute 1-4-1204 and the phrase, quote, alleged improprieties, he states that the phrase can, quote, only do so much. And then when discussing the timing issue under 1-4-1204, which we'll clarify in a second, Justice Birkenkotter describes the effort required to meet those deadlines, which are mere days, as an extraordinary effort, but also an effort that proves to be too much. It's my opinion that the two central issues in this case are the burden of proof issue and the standing issue. The burden of proof in the statute, if you remember, is the party filing the challenge, the petition, Anderson, has the burden to sustain the challenge by a preponderance of the evidence. That's the civil standard again, if you recall. The district court does come down with a clear and convincing standard, and then the Supreme Court again does say specific intent to commit. But that, to me, clarifies the issue. That statute was not, in my mind, intended to include in the language of alleged impropriety criminal acts, certainly not criminal acts involving complex litigation around insurrection. Another indication to that intent not to include those in that statute, in my mind, are the timing of the statute. Once a petition is filed, you have 5 days to respond to that petition. Then once you respond, the court has 48 hours to issue a judgment. that timing is not timing that is indicative of a criminal accusation. And then another issue for me are the cases that the Colorado Supreme Court used to justify the state's ability to exclude an individual from the presidential primary. The cases cited by the Colorado Supreme Court to exclude include Hassan v. Colorado, 870 Federal Supplement 2nd, 1192, and Socialist Workers' Party of Illinois v. Ogilvy, 357 Federal Supplement 109. In those cases, those were Article 2 cases, not the 14th Amendment, Section 3 cases. So in Article 2, to be eligible to be President of the United States, you have to be at least 35 years of age and a natural-born citizen. In Hassan, the plaintiff was a naturalized citizen, so they're born in another country, moved here to the United States and became a citizen. Then the Socialist Workers' Party, the party candidate was only 31 years of age. So those are express conditions. Those are clear. The court using those express conditions as justification to read in the implied authority, because there is no express authority in the Constitution for the states to regulate the presidential primary. They're using those to read that implied condition into the Constitution, and that just does not sit well with me. Those cases are, in my mind, very off point. So what I think is going to happen in this case is I think that the Supreme Court is going to side with Trump. I think that they'll see the statute as not including insurrection. I think that they'll look at the fact that the office of the president is not subject to Section 3 of the 14th Amendment. And I think that they will conclude that states have no right to regulate federal elections. As a consequence of that, the case out of Maine where the Secretary of State on her own initiative removed Trump from the ballot will be thrown out as well. And I think that's the basic outcome that I expect from this case. A closing note here, the judgment of the Colorado Supreme Court ordering Trump off the ballot has been stayed pending the outcome of the Supreme Court case. That being said, Griswold, the defendant in this case, the Secretary of State in Colorado, has recently certified Trump for the ballot in Colorado. So because of the stay, she acted to certify Trump for the ballot in Colorado. And that concludes our discussion of United States Supreme Court case number 23719, Donald J. Trump Jr. v. Norma Anderson et al. We will return to the issue of Trump v. Anderson once the Supreme Court has issued its judgment for a brief discussion of that judgment and look at where the case goes from there. And I thank you for your time. And as always, I wish you all the best of luck and nothing but the best in your endeavors. This episode has been developed by Brighton Ashford, has been produced by Tisher Hamilton, and has been hosted by Brent Risto.
Thank you for listening. Until next time.